Well, good afternoon, everybody. As everyone is joining this webinar, we will have the mandatory minute of awkward silence while we watch the numbers of participants climb. I'll start the webinar in probably about 45 seconds to a minute. So we will all sit awkwardly and stare at our computers for another 30 or 45 seconds or so. For those that are just joining, I'm just going to hold off another 30 seconds or so while watching the participant number climb before I introduce our panelists for this evening and start the webinar. Right, we will get underway. Well, first of all, good evening to everyone, and thank you for joining this Class Legal webinar, not just for judges, making use of the Equal Treatment Bench Book in practice. First, can I thank Class Legal for hosting the webinar this evening. I think it's the first ever webinar. Claire may correct me in a few moments' time, but hopefully not. But I think it may be the first ever webinar focused on the Equal Treatment Bench Book, which says that it aims to increase awareness and understanding of the different circumstances of people appearing in courts and tribunals. It helps enable effective communication and suggests steps which should increase participation by all parties. A particular focus of the webinar this evening is how it can be used not just to judges, but also to practitioners on both sides of the, all sides of the profession. Our attendees this evening are a mix of family, civil, criminal, and some, I think, non-legal practitioners. I would like to express a particular welcome to members of the International Association of LGBTQ+ judges, of which I am a member via my role as chair of the equivalent UK association. Format will be about 45 to 50 minutes of panel discussion, allowing, I hope, about 10 minutes for Q&A. Please do put questions in the box at the bottom of your screen, and I can pose those questions to our panelists as we go. I promise I shall finish at 5:45 p.m. on the dot. If I don't, I think Class Legal will end the call precisely at that time in any event. It gives me great pleasure to introduce our panelists and speakers. First of all, District Judge Clare Hockney. Clare is the lead author of the ETBB and a member of the Judicial Diversity Committee. Clare's been a tribunal judge since 2013 when she joined the Social Entitlement Tribunal. She was also appointed to sit in the Special Educational Needs and I knew I was going to get that wrong, Disability Tribunal in 2016. In 2019, Clare became a salaried district judge in the Family Court, undertaking child-related and Equality Act work. Clare's currently on long-term redeployment to the Health, Education and Social Care Chamber. District Judge Jamal Jeffers has been a salaried district judge since November of 2024. I don't know if this is actually the first anniversary of your appointment, Jamal, but probably very close to, so a happy first anniversary of your appointment. Jamal sits in the Leicester County and Family Court. Prior to his appointment, he was a specialist family law barrister dealing primarily with children work. And our third panelist is Mavis Amonoo-Acquah from Harcourt Chambers. Mavis is a family law barrister with a particular focus on children law, and within that, private children, international children, surrogacy, fertility law, and modern families. Her practice includes a significant amount of High Court work, and she's appeared in the Court of Appeal as junior to a number of leading silks. So I can't think of three better qualified people to talk about the ETBB. First of all, Claire, can I ask you, for those on the call who perhaps don't know, exactly what the ETBB is, who it's aimed at, how it can be accessed, and who the authors are?
Yes, well, it's thank you for that, and good, I think, evening to everyone, and particularly people in different time zones. But it's an online resource, and so that means it can be accessed by not just judges and barristers, solicitors, and other professionals. It can also be accessed by members of the public doing their own cases, and it frequently is, probably far more than actual legal representatives. Litigants in person do tend to get it and use it. And just so you know who we are, we've been online since 2018. It's a PDF, so it's relatively easy to search and find. And we have an editorial board, and that's made up of 10 salaried judges, but it also includes a specialist medical member who's a full-time member of the judiciary, and the head of legal at the Judicial College. And we are appointed via an appointments process, and we also now have a coroner on board because they're covered by the Equal Treatment Bench Book. And we appoint by looking at people's specialism. So we have people who are crime experts, family experts, people in the immigration, the other tribunals. And then there's opportunities, because I'm on the Judicial Diversity Committee, for specialist groups, such as gender, race, LGBTQ+, disability. We have a social disadvantage group. There are other judges. They can feed in to the bench book, and it's part of certainly the LGBTQ+ strategy to feed in to us as well. So we have that overlap. And so where the updates are. We have updates relatively regularly, every probably 9 months or so. If there's a very urgent case, we would update to take that into account. We're not dynamic in the sense that I update it every sort of week. I wish I could, but that just wouldn't be possible with the system we have. But we have a comprehensive review every 3 years, and the last one was in July 2024. And the current edition is the May 2025 update. So it's the July 24, May 2025 update. And following the last update, it has significantly reduced in size. And just very briefly, I think as Nick said, it is something that's there to raise awareness, and that's what it's for judges. And you may find there's a variety when you appear in the courts or tribunals. Some judges will know a lot about it if they're new. Perhaps they've been on training, they've looked at it for their appointment, whereas some of the older judges or longer in the tooth judges may not have had to look at it for some time, or may have passed them by. There's a new edition, so just be aware of that when you get it. It's there to help achieve best and effective communication. That's its purpose, and to get best evidence from people, and that's a really important aim. And if you think some judges come from very different backgrounds, and it may be difficult to understand cultural differences. What would you do if you have a gypsy or traveller person? What if there is someone from a very different background to your own that may be struggling to access the courts because they have no money? And not all judges, if they come from a commercial background, would necessarily know about that. I think that's the difficulties to know. Just so you know, we don't do external consultation. We do use documents that are evidence-based. People do write in from outside and say, we think this is something you should include, or this isn't correct. And we'll always look at that and take on board what people are saying. We may not always include it, but we would certainly look at it. And just so you know, I won't talk. I'll let the others talk in a minute, because I know I'm not to talk for too long. But it is guidance. Judges don't have to follow it, but if they don't follow it, and it was raised with them, or they should have been, they should have thought about it, then that could be a ground for an appeal. And there certainly have been successful appeals on the basis that it wasn't fair, the hearing, because judges haven't followed the Equal Treatment Bench Book. And certainly someone who I was speaking to, who said they do the sort of sift of appeals, said if they can see that the judges looked at the bench book, it's much less likely the appeal will get sort of off the ground. Conversely, if you haven't looked at it and you haven't looked at any of the rules, then it's much more likely as a judge you'll be appealed. So that's why for barristers and solicitors and lay advocates, if there's anyone here, I would say do refer to it. It's going to be very important in your client's case. But importantly, it shouldn't be used in place of any legal submissions. That's not its purpose. And I know that that's really important to stress. But that's just really an overview of where we are, who we are. We're 10 of us on an editorial board. When we make changes, it's an editorial decision, and looking at our range of evidence and supported by any external evidence that we can include.
Well, that's really useful overview as to how the ETBB works and how it's updated. Jamal, I'll come to you next, if I may. Certainly not a long in the tooth judge quite yet. Is it something that you were particularly aware of when you were in practice? Is it something that you became more aware of when you had your training? How have you sort of come to know and no doubt love the ETBB?
Cheers, Nick. Tomorrow is my anniversary. In fact, not today. So thankfully, and it falls on my late grandmother's birthday, so it's a nice memento for me to remember that of her. The ETBB was, I was aware of it in practice, but in reality, it became almost bread and butter at time of making applications for judicial posts, and since my subsequent long-term and salary sitting. I must have dipped into it, and I can almost remember dipping into it whilst in practice. But when you're actually making the decisions, I think one of the things that I try to guard against as much as possible is being that judge that is out of touch and can't remember and doesn't understand new developments and new things. And I think the ETBB actually helps me just a light touch, but to have a finger on the pulse on certain things. For instance, just this week, I have sitting with me this week a marshal who I know quasi-socially. I know his name. I don't know his last name. And I received an email from him, and I thought, oh, crikey, actually, I'm not sure of his name and convention. He is a Malaysian national, having recently come to the UK. And I know the name that he gives as his English name. And so when I read an email from him, I was flummoxed initially to think, when he comes in, how am I going to address to the parties who this person is in the formal way in which we do in court? And the ETBB got me out of a relatively sticky situation, because I would have to lose some face and say, actually, I don't actually know your last name, and I probably should. Can you help me out here? But actually, having read the chapter on it, a couple of paragraphs just helped me get through that situation, which I probably should have known. And so you say, learn to love it. I do, for that purpose, because it gives you, as I say, that light touch and indeed helpful steer. And Claire's quite right. Whenever the ETBB is quoted to me over the last year, the majority of the time has been by litigants in person, as opposed to anybody else.
Interesting. Mavis, turning to you, to what extent has the ETBB, at least to date, been of use to you in your role as an advocate?
So in my role as an advocate, I think it's been useful in terms of my role in being a shield for my client, and being aware of what is best practice in court and making sure that I, as my client's advocate, am able to ensure that that's actually being put into place by the judge and by other advocates. So for an example I can give you, I had a Muslim client. She was a woman in care proceedings, and she was due to give evidence. And I'd spoken to her before she gave evidence, as I do with all my clients, to ask about whether she wanted to affirm or to swear on the Quran. And she'd said to me that she wanted to affirm, and she explained to me her reasons for that, which were quite personal to her. So she went into court, she affirmed, and cross-examination began. And during the course of her cross-examination, one of the opposing counsel asked my client why she'd chosen to affirm rather than to swear in the Quran, implying that she was intending to not tell the truth. And I think from a personal and moral standpoint, that made me very uneasy because it felt like a very intrusive and personal question. But actually, it was more than an unfair question, because actually the bench book guidance makes clear that it's inappropriate to assume that a witness is not going to tell the truth just because they're not sworn on a holy book, and that swearing and affirming are to be given the same level of importance. And so knowing that, because I'd actually had the good fortune of looking at the bench book a few weeks prior for something different, recalling that, I was able to essentially jump to my feet and attempt to raise an objection. The judge in my case was already on the ball and said, that's an inappropriate question, so didn't let my client answer it, which was the right way forward. But I think had I been unaware that the bench book gave that guidance, I would have sat in my feeling of thinking, oh, this is an unfair and potentially intrusive question, but I may not have gone as far as to raise to my feet and say, I don't think my client is supposed to answer that question. I don't think it's appropriate. And I think as advocates, we are, of course, there to assist the court. And there are times when judges don't always hear things or miss things, and it's up to us to flag things up. And so, again, had I not known that that was an unreasonable question, I may not have flagged that to the judge. And had the judge not heard it, it may have gone unnoticed. And so it was an important way for me to be able to properly advocate and to shield my client as her advocate. And so I think as practitioners, knowing that the bench book exists and what it says is, I think, a really helpful tool to have in our arsenal as advocates for our clients.
And just a very quick follow-up, Mavis, if I may, as the representative on the committee of the entire profession on this call tonight. No pressure.
No, not at all.
To what extent do you think that there's a good level of knowledge amongst practitioners more generally? Do you think there might be a greater level of knowledge amongst those who do, for example, modern family work? What's your sort of take on that?
As to knowledge as to the existence of the bench book and what it says.
Or whether it's just for people, whether people tend to know it more if they do, for example, modern family work, where at least they may feel that these issues may come up more frequently.
Using myself as an example, I would say that I was entirely unaware of the existence of the bench book until I was thinking about applying for part-time judicial appointments. And someone I'd asked to mentor me advised me to go and look at the bench book and read the bench book, because it's helpful for the various tests you have to take for those positions. And so that's how I became aware of it. And I wonder whether, if I hadn't gone down that road to look at applying for part-time positions and I hadn't had that guidance from my mentor, I perhaps would still be in the camp of not knowing it exists, because I don't think it's widely publicised. It's certainly not something that had ever come to my attention. So if I am the lone person speaking for the entirety of the profession, I think it is something that ought to be better publicised, because it is a really useful tool, as I've said. So I don't think it's as well known as it really ought to be, because it's a really valuable tool. So I think steps should be taken to try and publicise the use of it more, in the same way that we do with the vulnerable witness toolkits that we have. I think it needs to be given that same level of push and publicity.
Claire, can I come back to you and thinking about how the ETBB deals with issues which one might say regrettably may have some controversy or controversy, depending on how one's meant to pronounce that word. And I'm thinking about, in today we have polarized views on trans issues, for example, that we see played out regrettably on social media that we're all familiar with. When there might be a perception that there isn't a consensus on a particular issue, how does the ETBB approach things like that?
Yes, that's a really good question, because it is the hardest thing. And what we try to do is to approach it. It's going to always be the editorial panel's decisions. It'd be something we discuss in our meetings. This is the way we're going to go, or this is what we think is appropriate and why. But we would also then make sure that we'd consulted with the diversity committee. Well, I would do that through my other role, that this is what we're thinking of. Do you see any difficulties with it? Now, of course, the problem is generally people with the trans issue, there is huge challenges, because what we've got in it now, which is not agreed with by a lot of people who are trans, is that it's all about trying to get best evidence. So how we've approached that is to say, based on sort of all the research we've been able to pull together, that taking to our core purpose, it's on best evidence. How do we get that? We try as judges always to call someone what they want to be called. But in those challenging cases, and that's not to imply that trans people are somehow criminals, but in general cases, I mean, I have a lot of trans youngsters come along for special needs. It doesn't really create any issue at all, unless there's an autistic parent that perhaps, there's odd case there. But generally, it doesn't create a difficulty to refer to someone as they want to be referred to. The same in social entitlement, it wouldn't create a problem. It's those cases where it might be someone has only ever known the person as the opposite, or their original birth or biological sex, and perhaps there's a rape or a crime, those very complex cases. Or increasingly, I do a lot with employment judges. They have very challenging cases where it's all about changing rooms. It's about the whole use of pronouns itself might be the case. And so the guidance is there to say in those circumstances, the judges try to be perhaps neutral. They might say they, or they might say doctor or nurse, or, sergeant major, or whatever the case may be. They try to take a neutral approach, and always reassuring the person very much who's there, that it's no disrespect intended. It's not. It's really to ensure the best evidence, and that things haven't been prejudged in those very difficult cases. But most cases, judges do call people what they want to be called, and that's in across the board for everything, really.
Jamal, then coming to you, one of the areas that I sit in the family division and the family court that we've become a lot more familiar with in recent years is domestic abuse, and in particular coercive and controlling behaviour. To what extent does ETBB, in your experience, kind of assist with those issues?
I think it's just quite greatly, actually. Over the last week and continuing into this week, I am sitting at the minute on a trial where I'm dealing with concerns of controlling coercive behaviour. I mean, as you say, Nick, it becomes part and parcel of our diet as family judges now and family practitioners. It permeates through almost everything. But it has, again, from my perspective, an opportunity of a bit of a touch point. The chapter on controlling coercive behavior is actually really good. It sets out a pattern of what the vulnerabilities may be of somebody who has been subject to such behavior, allows you to take a little step back if you have, as a judge, any thoughts in the back of your mind about the veracity of a witness, the veracity of the statements that are being put. It is easy, and almost immediately you have the opportunity and the thought process to dismiss some of the statements that are said. But then what you reminded, and I reminded myself by reading the ETBB, is to actually take another step back, and actually, if what these things are being said is true, there may be a reason as to why this vulnerability is there. It also, highlights some of the cultural difficulties that we may face when looking at controlling coercive behavior. And I think as a chapter that is, from my perspective, that works really well, that is one of them. It isn't, and Claire said at the beginning, not intended in any way to be legal guidance or something that goes beyond that which the case law already tells us, but actually in terms of what I need to know in 3 minutes before a case is brought on, as a touchstone, it is the right thing to help us out. Undoubtedly, people will say there could be more. There could be more in almost every chapter, but then we'd have an ETBB, I'm sure, of about 10,000 pages. I'm not sure that will be quite the thing that is necessary, but it is that starting point. And I think from a practitioner's point of view, I'm sure I would prefer some practitioners to read the ETBB when they are approaching the course, because actually it will make all of us treat the people whose very existence we hold in our hands during the course of our trials with a little bit more dignity, a little bit more respect, and an understanding of the harm that they're going through. I had cause to think just today, over the course of my career, we all walk into courtrooms and have lost, and probably do lose, the awe of what a courtroom does and the intimidation that a courtroom may be, because this is our place of work and it no longer holds that majesty. But once you step back and remember, for somebody who for this is the first time, or for this is their the most important period of their life, having having the bench book, having something to come back to that talks about their specific characteristics, may very well allow the judge, allow the advocates to focus back in on that one and those specific people, as opposed to the generality of what we get used to on a daily basis.
Interesting. Mavis, can I come to you and just perhaps ask you a question, a trans-related question, if I may? Obviously, Claire has said that the way in which the authors seek to navigate the competing arguments is to look at how somebody can give their best evidence to the court. In your experience of doing cases involving trans parties where issues have arisen in relation to trans naming, have you found the ETBB to be of assistance?
To an extent, and I say that because the ETBB that I think I was previously using was the one that hadn't been updated until I think May 2025, which Claire mentioned. So using the slightly older book and knowing that it's been slightly amended now, what it previously said, if I recall correctly, had given the parties, or had given us, a definition of dead naming, which is essentially using the birth name of the trans person, which they no longer use. And that was it. It didn't go further than that. But I think the new book indicates, as Claire said, that witnesses may refer to a person, a trans person, by their dead name if that is the name with which they knew the trans person. So there's been that slight change. But I think it needs to be made very clear the effect of using a trans person's dead name. And from my experience in cases, it's a very difficult thing for them to hear. And I don't wish to speak on behalf of the trans community, but just from my experience with my client, my understanding is that it often makes them feel unseen or even erased, because that's not their identity, that's not how they identify. And so I think the bench book perhaps needs to go a little bit further in making clear the importance to judges and other practitioners of not using a trans person's dead name. I understand the need to perhaps differentiate in cases where it assists the witness in giving best evidence. But aside from that, I think the message really needs to be drawn home, the importance of ensuring that the correct name is used, particularly for a trans person, and absolutely not their dead name unless circumstances and the need for a fair trial really calls for it. So I would say that, to answer your question, to an extent, yes, but perhaps there could be slightly more done to make that point clear, because it's a very important point, I think, for those identifying as trans, from my experience in those cases.
I mean, I'm sure, Claire, that is part of the evolving nature of the ETBB, isn't it? And that it's always going to be a kind of living document that on each iteration it does better in certain areas than the previous version.
Well, it always tries to. I mean, some people will say, well, they preferred, what it was before, because that was I'm saying it's something that they found easier to work with. And it's, as I say, it always comes down to our purpose, and it's about the best evidence. But then I recognise there's also people saying, well, if I'm a trans person, am I going to want to come to court if I think someone's going to dead name me? I'm going to perhaps be even afraid to take that step. And it'd be a very, imagine the sort of challenging case for a judge where someone is a trans person, they're a witness to maybe an assault, and they're just coming along to give their evidence, and someone tries to find out their research into what they might have been called once before that would be just perhaps put them off giving their evidence. So it might be that needs to be put somewhere and put appropriately in the bench book, so that it doesn't put people off coming to court or tribunal. But I would stress, in the vast majority of cases, there's no need for anybody to be referring to someone or digging around trying to find out a name. I mean, I could imagine it in a case where someone's recently perhaps transitioned, and it's maybe I had a case with a young person, and they would have found it difficult, I think, to suddenly refer to their father in a different way. But those are the sensitive cases, but generally, but that's really helpful to hear from Mavis on that.
Jamal, thinking of other cases or other areas where you found the ETBB to be useful. I think you mentioned to me previously that you've got some examples of cases involving pregnancy.
Yeah, so quite often, again, I do a lot of care work, and a lot of our work sadly starts initially on birth of a child, and we're pulled into court immediately. A case currently on its way where I'm due to have a trial in the early part of next year. This is not a care-related matter, but thankfully, hopefully, this mother will be giving birth towards the beginning of next year, and so I had to quickly again go back to the bench book and think it might not be the appropriate time for her to be giving live cross-examined evidence to me, either very near to her due date, or indeed soon after her baby is born, given the appropriate time for her. There is again another handy chapter about sensible times to wait, and I had to use that in the judgment that I gave about the question of delay versus what is appropriate to allow somebody to give their best evidence to me. again, that touchstone to be able to bring these things to the fore. It is just, I think I've said this earlier, but from a judge's perspective, we have 100 different machinations of things going around in every single case or on every single day, and all of them can't necessarily stick in your mind. I know they tend to do in my DF but I don't seem to have her memory. But in order to do justice to something, to have, I've got it open now. You have the book open. You know, for instance, it's pregnancy. Type in pregnancy, and up comes the hyperlink and bullet points, things that I might need to think about. I have often said to counsel as well, or solicitors in front of me, what does the bench book say about this? Please go and find it whilst I go and do something else. Just in terms of assisting the court, assisting them, and assisting their clients. It can't be perfect because nothing in this world is perfect, but actually I think it does have that benefit for all to level the playing field somewhat, and just make sure that the experience that people have from our courts and tribunals are that can be as not as frightening as they would otherwise anticipate it to be, or indeed is just fair, and that's what we're here for, isn't it? A fair hearing, a fair hearing for as many people as possible.
It certainly sounds, Jamal, just thinking about the pregnancy example that you give, that where it comes into its own is prompting you to think of the right questions to ask or the right questions to think about. It doesn't necessarily give you the answers to those questions, but it prompts you to think about the right questions and ask the right questions.
Yeah, it can't give you the answer, because if it gives you the answer, then I'd be out of a job. but it must simply give you those counterbalancing and prevailing arguments, and where those arguments lie, and how we then weigh them up. That has to be, for my mind, the whole point of the bench book. Mavis touched on it earlier as well in terms of making applications for judicial posts. It was invaluable to me when I made an application for my fee pay positions. Things that crop up and how they should be looked at. Well,
yeah,
I get the answers there.
I'm going to come to the last section in a moment and ask you, Mavis and Jamal, what your thoughts are as to where the ETBB could perhaps be improved when its next iteration comes out. But before I do that, Mavis, just thinking about your work, under the kind of umbrella of modern families more widely, to what extent have you found that the ETBB has assisted you, assisted opponents, assisted tribunals with looking at modern non-traditional families more widely in terms of giving their best evidence or being comfortable that the court is for them?
I know you said we're going to go into the last bit in a minute, but I think my answer is perhaps going to encroach on that.
Then encroach on that quite happily.
I think it is helpful in part because there is a really helpful section on sexual orientation and the matters flowing from that, which of course feeds into modern families. So as far as that is concerned, I think that is the bench book is a helpful guide there. But I think when I think more widely in terms of modern families and things involving that, such as surrogacy or assisted reproduction, the ETBB is of almost no assistance. And the reason for that is because at the moment there isn't anything in it on those matters. And I do think that's where the ETBB does fall down a little bit. I think it's very, as I said at the beginning, a very important and useful tool. But when it comes to that area, particularly of family law, I think there is a very key gap there. And I think it's important because we see, certainly in my practice, an increasing number of surrogacy cases or cases involving assisted reproduction. And the terminology in those areas are incredibly important because it's very, very emotive. So, for example, if you have a lesbian couple who have conceived via IVF, say, but there is a dispute involving their sperm donor regarding parentage, is he to be referred to as the father, or is he to be referred to as the donor? And I think that's really important in those circumstances, because instinctively, the bench may refer to him as the father because societally that's what we may think he is, but actually that may not be the case depending on the facts. And it also may be particularly emotive for the lesbian couple who see themselves as a lesbian couple, and the inclusion of a father is intrusive into that. And it may also give them the feeling of the matter having been predetermined by the bench if they're calling him the father when that is the issue and dispute. And I've seen that in my surrogacy cases as well, where the surrogate, sometimes by the court, has been referred to as the mother, when that is not the role that she plays, that's not the role that she seeks to play. Or if there is dispute about parentage, the intended parents find it very difficult to hear the surrogate referred to as their child's mother when they see themselves as the child's parent. So I think it's really important to have that information, that guidance, and that terminology in the ETBB, because, as I say, we're seeing so many more of those cases. It's so highly emotive, and what may be instinctive in terms of what you call people may not be, and it often isn't actually the right thing to use in those cases. So that's where I would say, in terms of having my modern families hat on, I would urge those, and I think, Claire, you're the lead for the ETBB, to think about including that guidance in the next iteration of the book, because I think it's invaluable to practitioners and to the bench in terms of knowing the right and, I would say, neutral terms to refer to parties in those cases.
And do you find at the moment, Mavis, that in those kind of modern family cases, you will often get the bench asking for assistance from the advocates as to how to ensure that they use the right language and terminology?
Unfortunately, I haven't. In those cases where the bench has referred to the parties using what I would say are the wrong terms, I have often been the one to say to the bench that, we ought to refer to the surrogate as a surrogate and the intended parents as the intended parents, and so forth. I haven't, in my experience, and I don't want to speak to everybody because other judges may have acted in different ways, but I haven't had judges ask me what they ought to call the parties. It's often a case of they opt for a path and it's either happened to be right or it's been wrong and I've had to correct them. And I've been able to correct them because it's, my bread and butter. It's the area that I know a lot about, so I feel comfortable in correcting them in that way. But if you have an advocate, say, who is not necessarily often in cases involving assisted reproduction or surrogacy and may not know the appropriate terms, without the guidance of the ETBB, they too may be unable to guide the bench. So I think it's worth having to assist practitioners and the bench in terms of proper terminology in those cases.
Well, I'll come to you last on this, but Jamal, just picking this up on you, obviously you had the experience of doing family cases. You obviously fee paid at the time as well, and before you took the salaried appointment. Is that a lacuna that you've noticed in terms of practitioners and tribunals using the correct language in modern family cases, either when you're at the bar or now that you're on the bench?
I think I agree with Mavis, and I think it's a symptom, isn't it, of shortcuts that we use. And I can think of judgments and days where I go without saying a parent's name, and this is not in a modern family's perspective, but in a what I'd consider a run-of-the-mill family case, where I'd say mother and father and call it quits at that. And it's a symptom of a shortcut that I think the courts have fallen into. And slow to then come out of when we are faced with something that doesn't fit what is the cookie cutter mold. And it highlights, doesn't it, much what I've been saying about just that quick touchstone, that ability to say, all right, this is something slightly different. Let me have a look and see what the process is. And it might even just be, as Mavis says, a question that we ask at the outset. how do we refer to each people? How are people comfortable being referred to? And then it's easily done. But
I think
it is a whole. I think.
sorry to interrupt you. I was going to probably say probably sometimes judges need to have the confidence to ask the question in the right way.
Yes, absolutely. Because nobody, I'm sure, goes out to want to offend. That can't possibly be the way. But equally, like you say, being empowered to be able to ask the question without it being as if it's going to be offensive. And I know, speaking from a personal perspective, there is. I'm acutely aware of the power imbalance that I have in court versus everybody else in court, and so the fear of treading over that line inappropriately, or indeed inadvertently, it sits in all of those decisions and questions that you have to think. But I agree, there probably is a lacuna that we have to think about.
But Claire, coming to you, is that a sort of lacuna in what the ETBB currently has that you sort of acknowledge?
I'm certainly, it's never come up before. I mean, it might sound a strange thing to think, as Mavis has said it so articulately, and why it's important. And it wasn't something I came across in practice at all, but I recognise it is something that we should certainly be looking at. And thinking, maybe only for something very small with just the terminology, so that it can be a starting point for judges. Because in my experience, for most judges, they're busy and they're not trying to do things wrong, or they want more guidance than probably anyone can really give, because it's obviously not the role of the bench, but to actually provide the answers. It's the starting point. But it's certainly something I've got on my list of another thing that we do need to think about. And that's why we like doing these sessions and doing them with judges as well, because people say, well, it doesn't cover this, it doesn't cover things like alcohol syndrome, that is a big issue for lots of parents in the care system, or parents that have adopted will say that, and there's nothing about that. So thank you for raising it. I am always grateful. It doesn't always appear, and I can see that being quite controversial in some respects, but it's something that it needs to be tackled.
I was actually going to ask you, Claire, you mentioned it about drug and alcohol issues, because of course some of those issues, of course, now come up in FDACs for areas that have FDACs, and use of terminology there, such as to what extent alcoholism, for example, would be defined or used as an illness, and or whether terms are used to whether one avoids terms such as addiction when it comes to heroin or any other. Are those issues that you mentioned alcohol, but is terminology in respect of drug use something that is currently looked at into the ETBB?
I think there was something in about that. It would be more trying to. I think again, yes, it's trying to put it in sort of not in a blame way. So it's a bit like the people still use committed suicide, and of course it shouldn't be that, and or suicide attempt, and so it's got those in it. So it probably does need some more. We don't say these are things you must say. We just say they're. I think we say recommended in a professional setting, because otherwise people say, well, why are you controlling my speech? I describe myself like that. I think the word queer is something judges wouldn't use in a decision, but of course people can often describe themselves in that way and be happy to do that. Other people wouldn't be. And I think someone, so it's that sort of thing. It's saying this is what's generally recommended from our research, and it saves judges doing it. And we try to get a consensus, but it's not always, sadly, possible on that. But there's definitely a lot of research on that, about trying to, sort of not write it as a drug addict or an alcoholic. It's trying to put it in a slightly more respectful way, so that people perhaps feel they can participate more, for the judges using better, more appropriate language.
Jamal, then perhaps finally Mavis, before we wrap up. Jamal, have you had experience? I presume you have, obviously dealing with care cases where drug-related issues and alcohol-related issues arise. Again, where terminology can be very important.
There are, I can't count how many care cases that I deal with now that don't include issues in relation to alcohol and drugs, and terminology has to be important because there is a long-standing question of dependency and where we are and how people are able to meet the needs. And that, again, I have to balance the question of needs and in reality how a parent is able to do things. And my job, and I say at the very outset of every care case, is my aim and my goal is to make sure that you and your children are back together insofar as I can make that happen, as far as that is safe. I'm not in an FDAC court, so I don't have the support of the FDAC system, but I think that it's appropriate, and all of the parties, all of the advocates that I have in front of me accept the need that we all need to travel this way together, and the ability to do so is by not blaming anybody. And I think the help that you receive, and I don't know if I've received it from the bench book, but I'm sure I know it's in there, is that question of understanding where people are on a social level, their social positions and the social economic status, and in reality just seeing that person. I feel like a broken record because this is the thing that I'm saying here, but I think the beauty that the bench book gives us is an ability to see the person and the whole of that person, and not just the tribal issue that is in front of us. And so that's the only reason why I would commend it and say people need to be looking into it. You were going to ask us, I think.
Yeah, I was going to say, so are there other areas, Jamal, that you think that, I mean, obviously, Mavis has highlighted assisted reproduction or surrogacy. From your perspective, are there areas where you think the ETBB perhaps can be expanded?
I think there are always things that can be expanded, always. I remember as a barrister, I dealt with a case, and it was a question of race, and part of the issue was the animation of some African Caribbean clients that I had, and whether or not that became an issue in terms of their ability to give evidence and whether or not they were credible. It forms part and parcel of the bench book, but in that instance, as the advocate, I felt as if I was giving expert evidence to the court about as to whether or not this was animation that was just animation, or whether this was more than what it appeared. I don't know the answer, and I don't know whether or not the bench book can delve into the micro in that way. But that is an area that and again, I've checked the race section as well just today. It's an area that I think is lacking, but I'm not sure how much more in reality you can put into it, and because it needn't be all the answers. It need be, as we've discussed, the ability to allow somebody to ask even further questions.
It's prompting the right questions,
yeah,
rather than necessarily giving the answers. Claire, I'll come to you for the last word in just a minute or two, but just turning back to you, Mavis, before I do, I saw you nodding, I think, when Jamal was saying that the ETBB can help a court see the entire person rather than simply the tribal issue in the case. I thought that was quite a nice sort of encapsulation of what it perhaps is there for.
No, I entirely agree. And I think it really comes to the fore in cases involving race or culture, where there are cultural differences. I think Jamal spoke earlier about naming conventions, which is a really helpful thing, which is in the ETBB as well. And that's all part of seeing the person and seeing the whole. And I think it also comes into play when we look at modern families and the different family structures that there are. That is also part of seeing the person as a whole and not just the case. So I entirely agree, and I don't think I could have put it any better, so I don't think I'll try to.
There we are. Claire, I'm going to give you the last word in the last couple of minutes. You have that privilege as the lead editor of the ETBB. Where do you hope it evolves to? Do you have sort of somewhere where, rather than in addition to just kind of iterations, is there a particular kind of medium-term goal, or where do you see the ETBB heading in the medium term?
I mean, I'd say just to have it so that really every word in it matters. So there's taken out anything that isn't necessary, because judges and everyone is busy, and to ensure it keeps up to date and enables judges to do their best job. And I think it's helpful again for Jamal to raise about cultural awareness, because that was a section that I think is really useful, reminding judges that someone's angry. It might be because they're animated, it might be their culture. But again, that section is very old, so it does need an update. And how is that updated, and on what evidence? And that's a challenge for us going forward. But I'd like to see it as something going forward, that it's a document or a book that barristers and solicitors do use, as well as judges and, as I say, members of the public, because I think it's I'm very grateful, Nick, for it being promoted through this forum to try to get people look at it. Really helpful on reasonable adjustments we haven't mentioned, but it's incredibly useful for both sides. If you are an advocate and you're faced with someone making very onerous requests, you can look in that. And as a judge, it's very useful to be able to refer to it as it's changed. So that's what I'd say. Aim to be useful, aim for you to understand the person, and aim for it to be used.
Brilliant. Well, we'll leave it probably there. Can I express my thanks to Claire, to Jamal, and to Mavis for what I hope everybody on the call, and the vast majority of those people, I kept a beady eye on the ticker, and we haven't lost that many people over the last hour, which is always a good sign. I found that fascinating. Speaking personally, I can only echo what everybody has said about the quality of the ETBB as a resource, both when I'm sitting and when I'm doing the day job. And I'm hugely grateful to Claire, to you and your fellow authors for the time and care that you put into the resource. I'm sure, Claire, if people on the call have got particular additional areas to those that Jamal and Mavis have highlighted, you won't mind them contacting you and making suggestions to the resource can be even better as we go forward. But in the meantime, can I thank everybody for joining, and I hope to see you on a future Class Legal webinar soon. Have a good evening, everybody. Thanks. Bye-bye.